Assalamu alaikum. I'm happy to be presenting today here before all of you. In a brief introduction, we'll be presenting today about cyber laws and data security in Oman from a legal perspective. So before we start and commence our presentation, I'll just give you a brief about myself and my background so that it will help you better understand this presentation. So by way of introduction, my name is Mohammed Al Khalili. I'm a partner at Al Khalili, Al Ghailani and Co. It's a law firm. We are working in different sectors of law, corporate, litigation, arbitration, mediation. So if you have any questions after this presentation, I'll be more than happy to take your questions and queries. So before we start or we head in our presentation, there is a useful practice for us to understand. So I try to simplify it as much as possible. Our presentation, it's covering cyber law, and the other aspect of it, it's the legal side. So we need to understand the legal hierarchy of laws here in Oman. I'm sure most of you already know that, but just a refresh on some of these points. So the legal hierarchy of laws in Oman, first of all, we have the basic statute. Basic statute is basically, it's like a map that sets the way for all other laws. All of these laws, they need to be in conformity with the basic statute. So the basic statute has been incorporated or issued by Royal Decree 6 by 2021. And the process of issuing basic statute, as you've seen, it's through a royal decree. So a royal decree needs to be issued by His Majesty. And then that's the process on how basic statute is created. So this was issued in 2021, as we previously stated. The relevant laws that we are going to cover in our presentation today, they are issued through a royal decree as well. The process of incorporating or issuing a royal decree, it's done either the point is raised through the relevant authority, and then it will be deliberated or discussed by Oman Council. Council of Ministers as well, they are involved in this process. It will be raised to His Majesty. The Majesty will approve the royal decree or the law, and based off it, the law will be issued. Obviously, he can have some comments on it. He will send it back to the council. The council will have their input, and then it's sent back to His Majesty. The third point, and as you've seen, basic statute and the laws, they are both issued through a royal decree. And the only way to revoke these two is basically in the same manner that they were created in. So if it was created by a royal decree, the only way to revoke it or amend it is through a royal decree as well. The third of which is basically executive regulations. And as you will see in most laws now, they will have an executive regulation relating to the law itself. The good practice about executive regulations basically is it is easy to amend. So the law, in principle, it will be more general. It will cover bigger, or it will be more broad in its content. And after that, a number of these points, they will be issued through a regulation. Why is that? A regulation is issued by the authority's head. So the process to make any changes, and as you've seen, especially in this field, the process to make the change, it will be in the same manner. So the minister or the head of that authority will be the person who will basically make such changes. Obviously, there are other sources of law that we can rely and depend on, but as I said, we are just touching surface in here. No deep web, no dark web, just the surface. So we move further. With regards to cybersecurity and data protection, the legal arena or the framework here in Oman, it is basically covered by 2 laws. So we are going to cover some parts of these laws in brief. We'll try to summarize it as much as possible. And then obviously, if you have any questions or queries, I'll be more than happy to take those queries. So in this field, we are having cybercrime law, which was issued by Royal Decree 12, 2011, and personal data protection law issued by Royal Decree 6, 22. And personal data protection law will start or will commence first with that. As you will see, it is just recently started. And we'll talk about the relevant authorities, and we'll talk from the prospect of the owner of these personal data. So something to consider about the laws. Obviously, laws are set by humans. So it will make common sense. Humans will be stating or having things that will make common sense and for them to apply and adapt in the future. So the relevant authorities, we spoke about the laws, the relevant authorities relating to this matter, the first of which is Ministry of Transport, Communications, and Information Technology. Second of which has been presented earlier by my colleague Mazen Al-Shakhsi, is a Cyber Defense Center established by Royal Decree 64, 2020. Obviously, in such case, because of the sensitivity of the data that's being controlled, it is reporting to Oman Internal Security Service. And then the third of which we are having Oman Information Technology Authority. So these are the relevant authorities. We proceed further. The key perspective to consider when we read the law, as we stated earlier, it was recently, or it came to effect just recently this year. So we are still awaiting the executive regulations relating to this royal decree. Prior to this law, and because there are some parts of it that are relating to electronic transactions law, so there are some parts of it that are targeting both these set of laws. So, and in most laws you will recently see, there are, in the most recent laws basically, they will state if there is any contradiction between these 2 laws, it will have a reference to the previous laws as well, the latter law shall proceed, so, or shall prevail. So in such case, if there is any contradiction between the current laws and the previous laws, the new laws shall apply. One of the most important terms to consider in this law, as the title of the law reads, it's basically what is personal data. So we're talking about personal data in this aspect. So personal data is data that makes a natural person identified or identifiable. Not just that, the law didn't state or didn't stop at this point. It makes it whether directly or indirectly by reference to one or more identifiers. It is worth to know the identifiers that are being stated in here, there are multiple identifiers, and they have been identified in the law. First of which, basically, if we are having genetic identifier, and then we are having biometric identifier, we are having health identifier as well. From the terms themselves, the genetic identifier, an example of it is basically DNA. I think that's the most fair word. Biometric identifier, the easiest example we can have in this case is fingerprints. And with regards to health data, one of the easiest examples we can have in such case is basically a health record of a person. So all of these points, they are having some sort of confidentiality relating to it. And that's why the Omani regulator, wisely, he covered these points. They gave them some sort of security. And obviously, if they are being jeopardized, there are penalties against those. So moving forward, the legal framework around data protection and cyber laws in Oman. I think this just brought me back to the previous slide. But we really worked on these images, no copyrights, so take a moment. Okay, so we move forward. If I'm just going to summarize the law in one term, because as we said, in this case, we are talking about personal data. So the most important summary to have of the law, basically consent. So we are having personal data. However, if there is consent from the other party, so that other party accept such usage of this information, then obviously we are at no issue. However, the Omani regulator, he wisely requested that such consent needs to be clear, it needs to be proven, and it needs to be written. So if there is any sort of consent, that consent needs to be very clear, as we stated, it needs to be proven, and it needs to be written. So we need to consider these factors. One more thing to consider. So if that personal data is infringed or is at risk, the owner should be informed about such infringement or change that's made to their data. So owners need to be notified if their data being subject to processing, purpose of processing their data, details of controller and processor, and their rights. We are going to tap these rights further as we speak, but we're just giving a brief summary. And as I told you, the laws that we are covering today, they are very extensive. So unfortunately, because of the time limits, we can't cover all of them, but we are as much as possible trying to cover whatever we can today. So note to take in consideration is basically one of the things we are, I think all of us, we are suffering from, is advertising and marketing. So we receive these messages quite often. So in such case as well, we need to provide, in principle, our approval or our consent to such material. We are going to talk about some of the rights of the owner. So these rights, as I told you, the law, it's made by humans. It's meant to make sense. And as much as possible, because even if you consider law, it sets limits. So as much as possible, we are trying to have these limits, but we need to have or provide freedom to the parties. You need to provide them some sort of freedom. So that's why in the laws itself, it's not very extensive, it's not very detailed. And if there is anything further, then obviously it will be raised in the executive regulations. So we refer to some of the rights provided. We said the main point when considering data is basically consent. So as an owner, the owner has the right to provide consent and revoke consent. Obviously, providing consent, it's a process that starts before creating that relationship with the other party, with the processor. And revoking consent, it comes at a later stage. So if I already provided my consent, then obviously I have the right to revoke such consent. If that consent was already granted, then I have the right to amend, update, or block personal data. These are rights that are given to the owner of such data, just to ensure and make sure that his data is protected. We are having different controllers when we're talking about personal data. So me as an owner, I can request that my data is changed from one controller to the other, One of the things we can have is basically request erasure of their personal data. As we see in here, it has limited rights. That is basically in case or unless it was required for documentation or national documentation purposes. So if it was used for that purpose, then it's fine. But other than that, request of erasure, it's obviously granted to the owner. Considering that we are talking about data, possibility of having a breach or violation on such data, it's possible. So if there was any breach, the owner himself, he might not be informed about such breach, but he will need to be notified by such breach by the controller. So even if one of the things we see, for example, with relation to top tech companies, sometimes their systems is hacked. So if there is any sort of or type of hack or change in these data, the owners shall be notified. Not just that, the law further provided the right to complain to the ministry. So if there was anything that was not stated in these points previously covered, the owner himself, he can complain with the ministry. One point to consider, as we stated earlier, so we're having the law. Process of issuing the law, obviously, it's much harder compared to process to issuing regulations. So we are still awaiting the regulations on this law, and we are expecting the regulation, obviously, it will cover these cases in further detail. Plus, it can have further rights or limitations on the controller. Okay, so when we are talking about these laws, we need to consider two aspects, basically. We need to consider the personal data of the individual, and at the same time, we're talking about a bigger data, which is basically the state or country. So there are some parts of the law that are not covered, which is basically to protect the bigger interest in such case. So when does the law not cover? In case of protection of national security or public interest. So if such data is infringing or risking national interest or security, then obviously in that case, it will have some sort of limitations. Same happens if it's in relation to economic interests of the state. Plus, at the end of it, we'll come to some points that you will come to understand and know better. In some cases, we are having public officials. Those public officials, because of their position or designation, they are having some obligations in their work. Those obligations request them to have some access to these data. So in that case, public officials will have such liberty. One more thing to consider is if there was any verdict by a court or an order by a court that requires accessing some of this personal data, then in that case, obviously, it will be considered. And for the purposes of research, because you know how vital and important having research is. So for the purposes of research, such data can be used. However, there are limitations to it. So even in this aspect or point, these limitations have been considered. So use of research is possible, or data in research is possible, provided no indication or reference related to the data subject is made. So as we stated earlier, if you recall our talk about personal data, we stated it makes a person identified directly or indirectly, or identifiable directly or indirectly. So in such case, provided that condition is not met, they can use this in such research. We consider, or we move forward. one of the points we covered earlier, we stated there are a number of indicators that we can use in order to identify a person, such as genetic identifiers, biometric identifiers, health, race, ethnicity. All of these are considered and factored. So in such case, it might require a further permit by the ministry. So if we are going to use such data, in addition to the authority or the approval of the owner himself, we might need a permit from the ministry. And if he was a child, then in such case, consent of the guardian is required.
Mr. Mohammed, time is finished.
Okay, sorry. So we consider, we move forward on breaches of personal data. There are a number of points that we need to consider and factor. With regards to the penalties, I will read them as they are for the sake of accuracy. So breaches that result in destruction, disclosure, access, or processing of data in an illegal manner shall be notified to the ministry for actions. As you can see, even the fines in here, they are not small fines. So the fines, they can not less than 15,000, and it can reach up to 20,000. Violations may incur a fine not less than 1,000 riyals up to 5,000 riyals. One of the points that we need to consider, if there is transfer of data abroad, because obviously of the risk it entails, such fine can reach up to 500,000 riyals. We continue further. As we said, we have data protection law, and we have cyber crime law. Cyber crime law, it was issued by Royal Decree 12/2011, and basically it targets or it covers crimes that are used or against a computer or a network, or whereby a computer or network was facilitated for such crime. Plus, it entails other penalties as we'll go. We covered some of those penalties, and we'll try to cover them briefly. So the law itself does not provide for formal definition of cybercrime. And this is, I think, it's challenging at times. So in such cases, having a clear definition of the cybercrime or to what it covers, it will give clarity to the dealers of the law to understand what is covered in such law. But in this case, it was more broad. It covered a number of cases without having a clear definition of cyber crime. So there are some examples provided under cyber crime. We'll cover as they are. Violation of safety, confidentiality of data and electronic information and the informational systems, misuse of information technology tools, forgery and information fraud, content crimes, trespass on credit cards. So there are some definitions that we are going to cover, but considering the time limitations, we'll pass on these. We'll continue further on the penalties we are having. So as we stated, the law is having some penalties against, or if you read the law basically states the penalty, and then it states what is the crime. So each of these crimes, they have or they come with a penalty. One of the penalties, or one of the points, the important takes to take on the law is basically that, as we stated, there are a number of crimes that are covered, as we covered earlier. However, I like the definition of banks and financial institutions. Because of how sensitive this data is, banks and financial institutions, they have been granted as governmental information. So if there is any breach relating to banks or financial institutions, because of how sensitive this data is, they have been regarded as governmental information. And as you will see, the penalties relating to these are higher or bigger compared to a regular crime. So in such case, if there was any deletion, change, amendment, or disfiguration, destruction, damage, or dissemination of governmental information, it will result in imprisonment not less than 3 years and not exceeding 10 years, compared to 1 year and 3 years in other cases, plus a fine of 3,000 to 10,000 riyals. There are other areas that are covered by the cyber crime law. As we stated, the law applies penalties to persons who use or access information network or information technology with the intention and purpose of committing cyber crimes. One of the takes we have on the law is basically definition of cyber crime. So rather than providing a definition, it just came with a list of examples that are covered in such case. The law additionally covers use of information technology to forge information, use of information technology to incite illicit behavior, such as gambling, and use of information technology to promote acts of terrorism. So, as we provided earlier, it further covers e-commerce. So there are a number of penalties that apply in such case. So the law governs the use of information with respect to financial cards, inclusive of intention or appropriate or facilitation, appropriation of the money of the others. So if we are using these tools for such purpose, then obviously it will be considered as an electronic violation. And in addition to it is forgery of financial cards. Obviously the focus on these is because of their sensitivity and need in such laws. I thank you all for listening today. I'm happy to be around you all. Thank you very much.